Yeah, I'm in.
Robert Harris. Oh, hold on. State your name.
Robert Harris.
Okay, you got him. Okay. All right.
And
Go
Your
ahead.
Honor, we are very close.
This right here is a critical courtroom moment when attorneys say they're close to a resolution. It usually means a plea deal or negotiated outcome is on the table. But here's the question. Is this a smart compromise or a rushed decision under pressure?
To working out a resolution on this matter. A resolution up in circuit court. We were just trying to figure out the terms of that. So we would ask for a brief adjournment in order to do.
Probable cause conference will be adjourned May 14th, 2026, 9 a.m.
Thank you very much. Mr. Harris, I'll be in touch.
All right. Thank you. Thank you.
Thank you, sir. Court calls case People versus Daniel Heelan.
Yes, Judge. Oh, he's here. Ready for assistant public defender on behalf of Mr. Eland. Looks like he is on. Judge.
Yes, he is. Sir, state your name.
Well, we tried to reach out to Mr. Heelan.
Oh, did he say his name? Okay, you're gonna have to take those headphones off.
And here's a reminder, courtrooms, even virtual ones, are not casual spaces. Technical issues like this might seem minor, but they can affect how seriously a defendant is perceived. First impressions. They matter more than you think.
Because that's not gonna work. Well, you gotta turn them off because we can't hear you.
Okay. How about now?
There we go. Yep, we can hear you now.
Thank you, Judge. We reached out to Mr. Heelan and did not have any contact with him. I did not know he was going to be here, but I'm glad to see him. I am asking for an adjournment and asking that he call our office so that we can have a conversation about his case.
Has he been testing?
I do not know, Judge. Mr. Heelan, have you been tested?
Hold it. You were in Bear River, right?
Yes, Your Honor.
Yeah, okay. That's why.
Okay.
All right. How much time did you need?
Just 2 weeks, Judge. And if
All right, Mr. Heelan, I'm going to adjourn your case out to May 14th, 2026.
Okay, Your
9
Honor.
a.m.
Thank you.
On continue. Call the public defender's office. They need to talk to you.
Okay, yes, sir.
You got that number?
Yes, sir.
All right. I want you to call it today so they have contact information.
Okay.
All right. Thank you.
Thank you, Your Honor.
Yep. Court calls the case. People versus Cecil Levine.
Mr. Louise.
That's who? That's him?
Yeah.
Sit down. Okay. Sure. Oh, you want to sit down? Yeah, it would be okay if he sat. He's not feeling.
Oh, yeah, sure.
Thank you. Mike Gaddy, Assistant Public Defender for Mr. Levine.
Your name, sir? Thank you.
Your Honor, we'd ask to set these matters for a preliminary examination.
When you say these matters, I have.
This matter, my apology, Judge, this matter.
You have all discover?
Yes, I believe we do, Judge. The mate, I know Your Honor's been giving May 12th. I don't know if we could have a week later. He has a medical appointment on the 7th.
Any objection to that, people? Yeah, we can do it. All right. So preliminary exam, and people would have their witnesses available the 19th. All right. Preliminary examination will be set May 19th, 2026, 9 a.m. That's before a judge. Garwood, is she paired with me? On the 19th. Judge Garwood.
Thank you. Your Honor, if I could be heard on a bond condition.
Sure.
Your Honor, Mr. Levine is currently wearing a tether.
Now this is where things get interesting. A tether is essentially electronic monitoring, think house arrest with tracking. The defense is pushing for flexibility due to medical needs, but the prosecution wants control. This is a classic balance between personal rights and public safety.
In the past, the court has allowed him to take the tether off for medical appointments, which he does have on the 7th. I have spoken to him, and he is going to be residing in Westland for the next foreseeable future, and we'll get that as to corrections. I was wondering if the court would consider removing yes tether going to be some distance from the alleged or at the very least allow him to at tether for any medical appointments where he is required to not have it, such as MRIs and things like that.
Your Honor, I would be fine with the removal other for medical on the documentations provided. We could do it by step. However, I would ask for a term in the meantime when we've not.
I'm going to agree with the people on that. I'm not going to remove his tether. Permanently, we'll allow it to be removed for medical purposes. Provided there's documentation regarding those.
Would Your Honor consider him just appearing at community corrections with the documentation, or do you want to step in order each time?
For his medical appointments,
Yes,
I'd want to step in order each time.
Thank you, Your Honor. All right.
Thank you. Court calls case people versus Dejan Holmes.
Would Ann need this?
Assistant Public Defender Donahue Lebo for Mr. Holmes.
Is he here?
Your Honor, this is again a case where I expected my client to be here, but it does not appear that that is happening.
Bench warrant will issue defendant's failure to appear.
And just like that, everything escalates. Failing to appear in court is no small mistake. A $10,000 cash bond and a warrant. That's the system sending a clear message: show up or face serious consequences. Was this a misunderstanding or a costly oversight?
Bond 10,000, cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls the case of the people versus Larry Mahan.
And on behalf of the people, Your Honor.
Michael Gaddy, Assistant Public Defender, on behalf of the defendant, Your Honor. I believe he's here by Zoom.
Yes, I thought.
Yes, I'm here.
All right. All right. So first, state your name.
Larry William Mahan.
All right. So first thing is, next time you appear, if you're going to appear via Zoom, can't be vaping in the courtroom.
Did you catch that? Vaping during a court session. It might sound trivial, but it speaks volumes about courtroom etiquette and respect. If this is how someone presents themselves in front of a judge, what does that signal about their case?
Understood?
Yes, Your Honor.
All right.
Your Honor, we're asking for a preliminary exam.
Okay. You have all discovered,
Yes, Judge.
and you have all discovery. People have their witnesses available at 12. All right. Set preliminary examination. This matter, May 12th, 2020. 9 a.m. before Washington. I would also indicate that there was a communication sent to the court, presumably from the victim. I don't know if that's where it came from. That's what it looks like. I will provide a copy of that to both counts.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you. Court calls case people versus Deshaun McFarland.
Stephanie Hanna, on behalf of Mr. McFarland, should be appearing by Zoom.
McFarland? Yeah.
Deputy F.
Now they even turn around looking at me. McFarland? Cannon.
Sorry, Your Honor.
Or really? Or not? You
I'm sorry, Your Honor.
couldn't even get that out in sincere fashion.
We're just asking for an adjournment. I know
I know, but he's got to be here. Not.
he,
All right. He gets called up in the next block because I'm not waiting.
I understand, Your Honor.
This moment feels tense, and for good reason. The judge is clearly losing patience. Repeated delays and absent defendants can seriously damage credibility. In court, timing isn't just procedural, it's everything.
What's he going to do?
He picked it up.
Oh, he picked it up after. Court does call the case. Armani Wardlow.
Levi Goldstein appearing on behalf of the defendant. It's your name, Mr. Armani Wardlow.
All right.
Your Honor, I am filling out a green sheet. I was just retained on this matter recently. And I have the written discovery, but I don't know if there are any videos because I have not been provided with any yet. So I'm asking for a 1-week adjournment.
And just like that, another delay, but this time a strategic one. More time means more preparation, more evidence review, and possibly a completely different outcome next time we're in court. Stay sharp because the next hearing could change everything.
1 week. I can give you 2.
I think to
The 14th.
14th. Let me check that real quick. Yeah, that'll work.
Yeah, I think we set some for you. May 14th, 2026, 9 a.m. Bound continue.
And I've got a green sheet for you, Your Honor.
All right. All right. Thank you.
Thank you.
All right. That's it for that block. You got to set up for 2. Then I'll come back. What stands in recess? All right.
Some people don't like places, so I don't know. Since I didn't see him, I don't do. What about like frozen house?
Like. Not the top 10 desserts, not the top 20.
What's it your opinion?
That makes sense.
If it's on the top 10 doesn't mean it's not good, because there's a lot of really good desserts.
Yeah.
Bakers are there, yeah.
Cherry pie. Lattice cup. Don't give me this top crust nonsense, what a lattice cup, one crystallized sugar on a lattice cup, one crunch, cherry.
But your peppers a local, I'll let it drink.
Maybe low for hydrogen. What? That sounds better, honestly.
You know, just get a parade by local right juice over.
Jello, and you're like making you a local. I mean, that makes sense.
That's correct. Well, I got me too. Got me too.
Yeah. I heard, I'm sorry.
It's so, that got me.
Hey.
I'm at Apple Brown.
Okay. Okay.
That's not.
Yeah.